Please proceed,
Thank you, Madam
Honorable
Speaker.
Fortun.
Thank you, Madam Speaker. As earlier said, Madam Speaker, there are several arguments against the reimposition of the death penalty. But this representation would like to zero in on four major issues. Number one, the abolition of the death penalty under the 1987 Constitution. Number two, heinous crimes as compelling reason for its reimposition. And number three, errors in conviction. And number four, international commitments of our country. I would like to go back, Madam Speaker, to the earlier debate on the abolition of the death penalty under the 1987 Constitution, which, because of insistence on an erroneous or flawed construction, has not been settled in the last 3 or 4 sessions that we have, or session days that we have been debating on this proposed measure to impose the death penalty. Let me state, Madam Speaker, Article 3, Section 9, Paragraph 1 of the 1987 Constitution. It says, excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. My first question, Madam Speaker, to the distinguished sponsor is very simple. Does the Constitution allow the imposition of excessive fines or the infliction of cruel, degrading, or inhuman punishment?
The Constitution is clear. That is not allowed. Madam Speaker, Your Honor.
Now, Madam Speaker, based on Article 3, Section 9, Paragraph 1, is the imposition of death penalty the rule or the strict exception?
The general rule is that death penalty has been suspended and shall not be imposed, and the exception is when there are compelling reasons for heinous crimes, the same may be imposed.
In other words, Madam Speaker, the 1987 Constitution prohibits the imposition of the death penalty, and if there be any exception, it cannot be just any exception that Congress may deem fit, but rather only the very strict exception provided for under the Constitution. Is that correct, Madam Speaker?
The exception is for compelling reasons involving heinous crimes. The Congress may provide for its reimposition.
Madam Speaker,
By
now,
law.
just a yes or no from the honorable distinguished sponsor, because this was already answered in the early interpellations. Did the Constitution abolish the death penalty?
It cannot be answered. It did not abolish, Madam Speaker, Your Honor, the death penalty. It merely suspended. And this is the same ruling of the High Court in the case of People versus Echegaray.
Now, when the Constitution was ratified and became effective, did it not have the effect of prohibiting already the imposition of death penalty by any court?
That is correct, but it provided for certain exceptions which authorizes Congress to provide for its reimposition.
Now, minus Congress, Madam Speaker, my question was very simple. At the time the 1987 Constitution was ratified and became effective, did it not have the effect of already prohibiting the imposition of death penalty by any court?
May I beg the pardon of
When the 1987
Your Honor,
Constitution became effective, did it not have the effect of prohibiting the imposition of death penalty by any court?
My response to that was that it merely suspended the imposition, and the Congress is allowed to reimpose it for compelling reasons.
Yes, Madam Speaker. Absent any law reimposing the death penalty, did the 1987 Constitution not have the effect of prohibiting the imposition of death penalty by any court?
That is correct. We
Madam
agree to
Speaker.
that.
Did the 1987 Constitution also not have the effect of reducing to reclusion perpetua all death sentences that had already become final and executory at the time the 1987 Constitution became effective.
That is correct. As in fact, that is what happened. All death penalty convictions were reduced to life in prison or reclusion perpetua.
And Madam Speaker, in the case of death sentences on appeal or under review at the time the 1987 Constitution was ratified and subsequently became effective, will the distinguished sponsor agree with this representation that whether or not death penalty may be imposed, should the court sustain the conviction of the accused, ceased already to be an issue? In other words, Madam Speaker, what was left for the appellate court to ascertain was the correctness and propriety of conviction of the accused by the lower court. But as to the penalty, the appellate court could not anymore, in any case and under any circumstance, sustain the imposition of the death penalty. Is that correct, Madam Speaker?
That is correct until Republic Act 7659 was enacted, which reimposed death penalty until in 1993 until 2006, when again 9346, RA 9346 suspended the same.
Yes, Madam Speaker. My question was, in the case of death sentences under review by the Supreme Court at the time the 1987 Constitution became effective, is it not that the Supreme Court could not anymore sustain the imposition of the death penalty? In other words, that is no longer an issue. All that the court could resolve was the propriety and correctness of the conviction of the accused. But otherwise, Madam Speaker, the decision to the contrary would be violative of the 1987 Constitution. Is that correct?
That is correct, as I mentioned, but then there was a law passed in 1993 which reimposed death penalty, and therefore during that time, which was also after the 1987 Constitution, reimposition of death decision imposing death penalty has been authorized by law.
What I was asking about was prior to the law reimposing the death penalty. At any rate, Madam Speaker, may I ask, in the case, Madam Speaker, of death sentences already imposed, when the Constitution said any death penalty already imposed shall be reduced to reclusion perpetua, did it not have the effect of permanently removing that death penalty and replacing it with reclusion perpetua?
What is the question?
In particular cases, Madam Chair, yung pong mga death penalty that were already imposed, when the Constitution provided that any death penalty already imposed shall be reduced to reclusion perpetua, di po ba ang epekto noon permanently reduced to reclusion perpetua yon?
Hindi naman po, Madam Speaker, Your Honor, kasi nga, sabi ng by specific provision of the Constitution as well, ay pwedeng i-reimpose yan for compelling reasons involving heinous crime. So malinaw na malinaw po yung ating konstitusyon na hindi permanente yan dahil pwede pong ibalik yan, and that can be found in Section 19, Article 3 of the 87 Constitution as well.
Madam Speaker, my question is very specific. I am referring to death penalty already imposed. Yung pong mga death penalty na inimpose na po ng husgado at awaiting implementation na lang. At the time the 1987 Constitution was approved and became effective. The Constitution says, any death penalty already imposed shall be reduced to reclusion perpetua. My question was, is it not that that provision of the Constitution had the effect of permanently reducing to reclusion perpetua all death sentences that were already imposed
At that time.
at that time.
I agree, I agree. Wala naman po tayong quarrel doon sa pag-reduce ng death penalty to reclusion perpetua pursuant to the provision of the Constitution. Pero hindi ibig sabihin nito, permanente na yon forever.
Now, my next question, Madam Speaker, is this. Is there still any way or any chance under our Constitution or our remedial and substantive laws that those death sentences already imposed but reduced to reclusion perpetua by the 1987 Constitution may be revived or reimposed?
Wala po. Hindi po pwedeng i-revive na yon because laws are always interpreted in favor of the accused. And therefore, pag nagkaroon po ng constitutional provision na kung saan sinususpindi po yun, hindi na po pwedeng ibalik yon because the Constitution cannot be interpreted otherwise, as it will run counter to rules on statutory construction, where all laws and or even constitutional provisions must be interpreted in favor of the accused.
Thank you, Madam Speaker. At least that is very clear now, Madam Speaker, that the 1987 Constitution is abolitionist in its perspective on the matter of death penalty. Because the framers of the Constitution were very much aware that those death sentences that were already imposed but would be reduced to reclusion perpetua would be reduced to reclusion perpetua forever. And there is not any chance under our jurisdiction that these sentences that were reduced to reclusion perpetua could be again imposed with the penalty of death. Let me proceed, Madam Speaker, to another question on the matter of compelling reasons. Will the distinguished sponsor agree with me when I say that under the Constitution, the provision that says any death penalty already imposed shall be reduced to reclusion perpetua is clear and unambiguous, and therefore does not need any further interpretation?
We fully agree to that, Madam Speaker and Your Honors.
And, Madam Speaker, not only is this provision very clear and free from ambiguity, it is also, very importantly, immediately effective and does not need and did not need any enabling law to be applicable to any penalty of death already imposed and awaiting implementation at the time it was ratified.
We fully subscribe to that, Madam Speaker, Your Honor.
Now, Madam Speaker, does the 1987 Constitution recognize the possible existence of heinous crimes? Meaning, the Constitution already contemplated of heinous crimes, and this category of crimes is not something that crops up only after the 1987 Constitution was approved.
I think, Madam Speaker, Your Honors, the Constitution is clear and it is explicit in the Constitution that heinous crimes had been recognized as among the reasons, apart from compelling reasons for the reimposition of death penalty.
Prior to the 1987 Constitution, Madam Speaker, were there already heinous crimes committed in the country?
I would like to think so, because all of these murders and or kidnapping had been happening since time immemorial.
Thank you, Madam Speaker. And if there were there perpetrators of these same heinous crimes that are so considered under House Bill 4727 that were brought to justice and convicted to suffer the penalty of death.
Before the 87th Constitution?
Yes, before the 1987 Constitution, Madam Speaker, meron na po bang mga nangyaring heinous crimes? And the perpetrators of these heinous crimes were brought to justice and sentenced to suffer the penalty of death.
Palagay ko po, meron po. I can distinctly recall the case of the rape of Maggie de la Riva, where yung mga akusado po doon or yung mga convicted doon ay pinarusahan ng kamatayan.
Yes, Madam Speaker. In fact, the distinguished sponsor may perhaps agree with this humble representation that at the time the 1987 Constitution was crafted and finally ratified, there were sentences of death already imposed and awaiting implementation for the same crimes considered as heinous under House Bill 4727. Is that correct, Madam Speaker? Distinguished sponsor.
I'm sorry, I did not get the answer. Kasi we're talking here of prior to 1987 Constitution. Now, you are referring to 4727, which is not even a law.
I will restate, Madam Speaker, the question. Will the distinguished sponsor agree with this humble representation that at the time the 1987 Constitution was ratified, there were already sentences of death already imposed and awaiting implementation for crimes that are considered heinous under House Bill 4727. Ibig sabihin, yung mga nangyaring mga crimes na pinatawan ng death sentence at the time the 1987 Constitution was approved are the same crimes that are considered heinous under our proposed House Bill 4727.
Meron po, yung rape na binanggit ko, meron din po tayo sa bill natin ngayon kasama. And there are 20 other crimes that are incorporated in the bill as presently crafted and approved by the Committee on Justice.
Thank you, distinguished sponsor, Madam Speaker. And when the 1987 Constitution provided any death penalty already imposed shall be reduced to reclusion perpetua, will the distinguished sponsor agree with this representation that the Constitution did not distinguish whether the crimes for which death penalty was already imposed was heinous or not? In other words, the provision that says all death penalty already imposed shall be reduced to reclusion perpetua, the Constitution did not distinguish whether or not this death penalty was imposed for crimes that were considered heinous or for crimes that were not so considered heinous. Walang distinction ang nilagay sa ating Constitution.
I believe, Madam Speaker, Your Honor, that there is no need for such distinction because death penalty can only be imposed for crimes which are heinous. Hindi naman po mai-impose ng death penalty yung simple rape o kaya po yung estafa or something to that. It has to be gruesome. It has to be as defined by no less than the Supreme Court na ma-impose yung death penalty only for those types of crimes.
Suffice it to say, Madam Speaker, that the Constitution did not state specifically that only death penalty imposed on offenses considered heinous shall be reduced to reclusion perpetua. In fact, the Constitution only says any death penalty shall be reduced to reclusion perpetua. In other words, Madam Speaker, regardless of whether the crimes committed were heinous or not, all death sentences already imposed for the commission of these crimes without distinction were reduced by the 1987 to reclusion perpetua. Which brings me, Madam Speaker, to the next question on the issue of heinous crimes as a compelling reason to impose the death penalty. Will the distinguished sponsor agree with this representation, Madam Speaker, that because the Constitution reduced to reclusion perpetua all death penalty already imposed without distinction whether or not these were heinous crimes, the fact that there may be heinous crimes is not sufficient reason to impose death penalty. In other words, the mere existence or occurrence of certain heinous crimes is not the compelling reason contemplated under the 1987 Constitution.
The sponsor fully agrees with that heinous crime is not synonymous to compelling reasons, and this representation has already enumerated the compelling reasons for the imposition of death penalty for crimes which are for those involving heinous crimes.
In fact, Madam Speaker, distinguished sponsor, the Constitution says neither shall death penalty be imposed except for compelling reasons involving heinous crimes. It was not couched in this way. Neither shall death penalty be imposed except for heinous crimes. It says except for compelling reasons involving heinous crimes. In other words, the Constitution was couched in a manner that lays down a very clear state policy that the existence of heinous crimes alone is not sufficient to call for the imposition of the death penalty. The Constitution requires that there be compelling reasons involving heinous crimes. What could be one of these compelling reasons, Madam Speaker? Maybe widespread criminality involving heinous crimes could be a compelling reason, and this was cited by the Honorable Chair of the Justice Committee, our distinguished sponsor. May I ask the distinguished sponsor, Madam Speaker, if he is familiar with the Philippine Statistics Authority?
These data or statistics are not necessary for purposes of reimposition of the death penalty. In fact, as I mentioned in previous responses I made, if you will just read the papers, watch television, and or listen to radio, on a daily basis, you will hear that these crimes are being committed left and right. And to me, that is how I view that there is a compelling reason for this, for the reimposition of death penalty. In fact, the criminality that is happening every day is becoming graver and graver. In fact, even the President in one of his speeches mentioned that prior to the abolition or prior to the suspension of death penalty under RA 9346, there were only 189 convictions involving heinous crimes. But from 2006 until today, there are now about 6,000, or an increase in 3,000 by 3,000%. So, but I do not like to resort to the statistics or rely on the statistics for purposes of pursuing this bill on the reimposition of death penalty, because the Supreme Court, in the case of People versus Echegaray, had already ruled upon that is not necessary or a precondition for the passage of of House Bill 4727.
Madam Speaker, I was asking if the distinguished sponsor was familiar with the Philippine Statistics Authority, because the PSA serves as the central statistical authority on primary data collection in the Philippines. It collects, compiles, analyzes, and publishes important and vital statistical information. And according to the Philippine Statistics Authority, Madam Speaker, there was a significant, or there has been a significant decrease every year of the crime rate in the country. I would like to read for the record, Madam Speaker. It says here that for reported crimes, total for indexed and non-indexed crimes, in 2009, there was 502,665. In 2010, there's 324,083. That's a decrease of about 200,000. And in 2011, from 324, it decreased to 246,958. And in 2012, it decreased further to 217,812. And that is until 2012, Madam Speaker, according to the Philippine Statistics Authority data. But there's even a more recent data, Madam Speaker, and this is not only from the Philippine Statistics Authority. This one is from the Philippine National Police. This is the PNP Annual Report 2015. It says that in 2014, there were 900,756 murders. And in 2015, there's 9,643. There's a decrease. In the case of homicide, from 3,349, it went down to 2,835. For physical injury, from 65,763, it went down to 49,845. In the case of robbery, 43,726 went down to 31,741. And in the case of carnapping, from almost 14,000, we have now 12,000. Madam Speaker, these are very clear statistical data that there has been over the years significant decrease in the crime rate, both indexed and non-indexed crimes. That is minus the death penalty, Madam Speaker.
I'd like to commend the distinguished interpellator of all of this data he had just cited. But then again, I'd like to quote pertinent portions of the case of People versus Echegaray, which somehow rendered these statistics immaterial. So this is no less than the Supreme Court, which has already ruled upon the matter. So I could not comprehend why we need to further discuss these issues, most especially when in 1993, death penalty was already reimposed, and this was after the 1987 Constitution was already effective. Now, what we are doing, in fact, this bill that we are presenting to the floor, House Bill number 4727, is just a revival of the old law that has been upheld by the Supreme Court, which is RA 7659. So, with all due respect to distinguished interpellator, that perhaps we need not belabor on this point on statistics, because the Supreme Court had already ruled upon the matter.
Madam Speaker, with due respect to the distinguished sponsor, this representation begs to disagree that statistics is immaterial in the discussion on this matter, because it was the distinguished sponsor himself who raised as one of the compelling reasons for the reimposition of the death penalty the claimed fact that there is widespread criminality. And there is no way you can measure whether or not there's widespread criminality if you don't rely on statistics. That is why, Madam Speaker, the point earlier raised by this representation was that it is not enough that there exists heinous crimes, because there have been heinous crimes since time immemorial. There has got to be widespread commission of heinous crimes, so that probably may become a compelling reason for the reimposition of the death penalty. Now, how do we determine widespread criminality if we don't rely on statistics? That is why, Madam Speaker, this representation went the whole hog to gather the necessary data that would tell us whether or not it is true that there is widespread criminality, whether or not it is true that the absence of the penalty of death has been the reason why there has been a constantly increasing rate in crimes in the country. On the contrary, Madam Speaker, there has been no death penalty for like 1 decade already, and in the last 10 years, there has been a consistent decline in the crime rate in the country based on statistics, not only by the Philippine Statistics Authority, but also by the Philippine National Police itself, Madam Speaker.
It is unfortunate that the distinguished interpellator does not share the views of the sponsor on the matter, and equally of the jurisprudence established in People versus Echegaray. Ultimately, if there will be issues on legality or constitutionality, this will go back to the Supreme Court, and I don't see any reason why the Supreme Court will change its stand on the matter. At any rate, what we say here is only the position of this representation. Ultimately, what will matter is the decision of the entire or this August chamber, and ultimately this is what will spell the difference between approval and or disapproval of this bill.
Thank you, distinguished sponsor. Madam Speaker, suffice it to say, Madam Speaker, that based on statistics by the PSA and the PNP, it is not true that there is a constant increase in the crime rate. In fact, the statistics will show that there has been a significant decrease over the years. Nonetheless, Madam Speaker, may I proceed to another point? Let me proceed to another important data, and this has relevance to the issue of correctness and propriety of court decisions. Is it not, Madam Speaker, distinguished sponsor, that in the case of People versus Mateo, decided in 2004, when death penalty was still effective by virtue of Republic Act number 9346, no less than the Supreme Court admitted that 71.77% of decisions imposing death penalty that were elevated to the court on review turned out to be erroneous judgments. And in fact, there were cases that death penalty was not only reduced to a lower penalty, but actually the court rendered an acquittal in several cases, Madam Speaker.
What is the question, Your Honor?
Yes, the question, Madam Speaker, is that will the distinguished sponsor agree that based on a decision by the Supreme Court decided in 2004, when death penalty was still effective, there was an admission from no less than the Supreme Court that 71.77% of death sentences that were imposed and elevated to the court for review turned out to be erroneous judgments. And the Supreme Court, in several cases, did not only reduce the penalty, but in fact rendered an acquittal of the accused or the convict in this case, Madam Speaker.
Madam Speaker, Your Honor, I cannot go against the ruling of the Supreme Court on the matter. But if I will interpret it, it even bolster the fact that we need to reimpose death penalty because of the strict process that one has to go through before death penalty will be reimposed. In fact, after the lower court has rendered and handed the verdict of death, there is a mode of appeal to the Court of Appeals, and even if the Court of Appeals would sustain the decision of the lower court, and even if the convict or the accused will not appeal to the Supreme Court, there is a process which is the automatic review of a 15-member court that will review that decision of the lower court and of the Court of Appeals. So it provides for a process that I guess will safeguard the welfare of the people before any death penalty will be carried out. In fact, even before a death convict shall go to the death chambers, the President has ample powers, clemency and or pardon, to remove any death convict in the death row from being subjected to death penalty.
Madam Speaker, on the contrary, Madam Speaker, the admission by the Supreme Court that 71.77% of death sentences were erroneous judgments. This is an alarming data, Madam Speaker, because it only shows that we have a problematic criminal justice system. The errors could not be mere misappreciation of the cases by judges of lower courts. It demonstrates a problematic criminal justice system, Madam Speaker, because this may be caused by poor law enforcement, poor case build-up, poor prosecution. That is why we are unable to come up with accurate decisions. And, Madam Speaker, will the distinguished sponsor agree with this representation that unlike other penalties, like reclusion perpetua and lower penalties, in the case of death penalty, when a convict has already been executed, even if newfound evidence come out in the future, which under the law can be utilized to reopen the case, there is no more any chance to revive what has been imposed, to withdraw the death penalty that has already been imposed.
Definitely, because if a death convict has already been subjected to the punishment, then he will be 6 feet under the ground and there will be no more remedy for that. But then again, the process is there, and the process is tedious and judicious, and that is the process that is now being considered. There may be some flaws in the criminal justice system, but then the Committee on Justice had deemed it necessary also to reform the criminal justice system side by side with the reimposition of death penalty, because the Committee on Justice and our members felt that if we do not do something after 11 years of the suspension of the death penalty, if we do not do something about it, where will we go? Crimes are being committed left and right, and the gravity and the types of crime being committed are becoming graver and graver. And now even law enforcers are emboldened and had been emboldened to commit these crimes. And so there has got to be a change in the policy to somehow so that we can expect change. Otherwise, how can we expect that the conditions will change after 11 years of hibernation of death penalty if we will maintain the status quo.
Mr. Speaker, on the contrary, this is like a case of a cart ahead of the horse. If there is really a need to reimpose death penalty for compelling reasons involving heinous crimes, the admission of the Supreme Court that 71.77% of the death sentences they reviewed were erroneous should be considered very seriously by this Congress. Klarong-klaro po na ang daming pagkakamali. At hindi yan pagkakamali ng husgado lang. Nag-umpisa yan mula sa law enforcement hanggang sa prosecution, hanggang umakyat sa husgado, kaya nagkaloko-loko ang desisyon. We have a problematic criminal justice system. But we commend, of course, the efforts of our Philippine National Police, because despite the fact that there was no death penalty in the last 10 years, there has been a significant decrease in the crime rate sa ating pong bansa.
With due respect to the two gentlemen, may I remind the 1 hour limit rule. So please wind up your interpellations.
I will now go to my last point, Mr. Speaker. Since I only have a few minutes, I will just state for the record, Mr. Speaker, that our country was a signatory to the Vienna Convention on the Law of Treaties, which was signed on May 23, 1969. And that treaty says, a treaty which contains no provision regarding extermination and which does not provide for denunciation or withdrawal is not subject to denunciation or withdrawal. That is in 1969. In 1987, the Philippines ratified a new constitution under which it is provided that the Philippines renounces war as an instrument of national policy and adopts the generally accepted principles of international law as part of the land. But prior to that, Madam Speaker, prior to the 1987 Constitution, the Philippines ratified the International Covenant on Civil and Political Rights, reinforcing its commitment to promote civil and political rights, including the right to life. And in June 24, 2006, RA 9346 was passed and approved, an act prohibiting the imposition of death penalty in the Philippines. And subsequently, after we signed the Vienna Convention on the Law of Treaties in 1969, ratified the ICCPR in 1986, ratified our present Constitution in 1987, we signed in February of 2007 the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of death penalty in our jurisdiction. May I read, Madam Speaker or Mr. Speaker, the specific provision? No one within the jurisdiction of a state party to the present protocol shall be executed, and each party shall take all necessary measures to abolish the death penalty within its jurisdiction. Article 2, Mr. Speaker, of the protocol only allows reservations made at the time of ratification, and the Philippines did not make any such reservation. Madam Speaker, or Mr. Speaker, not only that, we have been very actively reiterating our commitment, because after all these international instruments, meron pa pong mga sumunod. In December 18, 2007, we sponsored, we were not only in favor, we did not only ratify this, we sponsored the resolution adopted by the General Assembly on December 18, 2007. The resolution reaffirms in unequivocal terms the commitment of the UN towards the abolition of death penalty. After that, in 2008, we also ratified resolution adopted by the General Assembly. It had the Assembly welcoming the global trend towards the abolition of capital punishment and also welcoming recommendations contained in the Secretary General's report on the implementation of the 2007 resolution calling for the abolition of death penalty. After that, there's another resolution that we ratified, December 21, 2010, resolution on the moratorium on the use of the death penalty. And in 2012, there's another resolution that we ratified. The Assembly advanced its call to end the use of death penalty with the passage by recorded vote of 111 in favor to 41 with 34 abstentions, calling for moratorium on the death penalty. And also very recently, Mr. Speaker, there's another resolution that we ratified in 24 June of 2014, calling upon all states that have not yet acceded to ratify the second optional protocol to the International Covenant on Civil and Political Rights to already call for the abolition of death penalty in the respective jurisdiction. And the most recent, Mr. Speaker, is a resolution adopted by the General Assembly na tayo ay hindi lang pabor, kundi co-sponsor pa. Resolution na nananawagan ulit para tanggalin na ang parusa ng kamatayan. Sunod-sunod po ito na mga commitments natin, hindi lang po yung second, yung protocol. Marami pang sumunod after that. There are about 6 or 7 resolutions that we did not only ratify, in fact, in a few of these resolutions, sponsor pa po tayo. I'm just reiterating, Mr. Speaker, that these are international commitments, and when we ratified these commitments, Mr. Speaker, we were conscious of the fact that in 1969, we were a signatory to the Vienna Convention on the Law of Treaties that says that all instruments na wala pong withdrawal at denunciation ay hindi po subject sa denunciation at withdrawal.
Thank you,
Mr. Speaker. My time is already up. Thank you, distinguished sponsor.
Mr. Speaker, Your Honor, just to respond to that, 2 points.
Proceed, Mr. Sponsor.
Just 2 points, Mr. Speaker, Your Honors. Earlier on, he cited a Supreme Court decision, and his view is that this is effectively an indictment of the reimposition of death penalty, which I also cannot agree on, because on the contrary, that decision will also manifest that the criminal justice system is working. And this is precisely what we're saying, that when we reimpose the death penalty, there will be a long, tedious, and judicious process that a death convict shall go through before.
Thank you, Mr. Sponsor. May I remind you that you are also included in a 1-hour time limit rule.
Yes, may I request for just 1 minute just to finish off?
Just a minute.
Yes. So that decision is also shows that our criminal justice system is working. On the point of all of these international treaties, conventions, international laws that form part of the law of the land, suffice it to say that these treatises and or international agreements cannot be above our Constitution, which is explicit that Congress is authorized to reimpose death penalty for compelling reasons involving heinous crimes. Thank you, Mr. Speaker. Thank you,
Speaker.
Your Honors.
May I also be accorded 1 minute to conclude, Mr. Speaker? Just 1 minute, Mr. Speaker.
Just a minute. Just a minute.
Just to reiterate the fact, Mr. Speaker, that based on our discussion, it is very clear that the death penalty was abolished by the 1987 Constitution, and the 1987 Constitution has an abolitionist perspective on the matter of death penalty. Also, that the mere existence of heinous crimes is not enough compelling reason for the reimposition of the death penalty. And it has been established that there are not a few, but several errors in the conviction. And also, Mr. Speaker, we cannot renege on our international commitments on the abolition of the death penalty.
Thank you,
Mr. Speaker.
Honorable
Thank you,
Fortun
distinguished
from the
sponsor.
1st District of Agusan del Norte. The Majority Floor Leader.